Yes. Good evening, everybody. Today, we have all gathered here for starting with the first SCAORA AOR lecture series for 2025. I, Dr. Meenakshi Kalra, welcome you all on behalf of the SCAORA to this lecture series. Today, we have all
Good evening,
gathered.
everybody. Today
Today
we have all gathered here for starting with the first.
Today, we've all gathered here to start with the lecture series. We have the honor to have with us today Senior Advocate Gagan Gupta, sir. We welcome you, sir, and we're thankful to you for taking out time. Sir will deliver lecture today on practice and procedure. We're showcasing live on YouTube, and if anybody has any questions, the same may be put in the chat box, and the same will be taken up at the end by sir. I now request our secretary, Sir Nikhil Jain, sir, to start with the session.
Good evening, everybody. Today's lecture is on practice and procedure, which should be delivered by Gagan Gupta, sir. And he would deal with all the judgments and all the last question papers which are there in the examination. And he will be elaborately teaching you about practice and procedure.
I would now request my privilege to introduce sir. Sir, it's my distinct honor to introduce to you as an eminent legal luminary. Gagan Gupta, sir, with a distinguished career spanning 2 decades, has made a significant contributions to the Indian legal system. Gagan sir completed his law degree from Delhi University and started practicing in Supreme Court in the year 2000. And he obtained rank 2 in the AOR examination conducted in the year 2007. Sir has a distinguished legal luminary, has an experience in the Supreme Court of India and other esteemed courts and tribunals. With a stellar academic record and a proven track record of excellence, Mr. Gupta has established himself as a leading authority in various areas of law, including constitutional, civil, criminal, and corporate matters. As an advocate on record and a senior advocate, he brings unparalleled expertise and insight to the legal fraternity. Let's hear from Gagan Gupta, sir, today about practice and procedure. Throughout his career, Sir has been involved in numerous landmark cases in recognition of his outstanding contributions to the field of law. Beyond his professional achievements, Sir is known for his commitment to mentoring young legal minds, having guided numerous juniors during his tenure. Now I would request Sir to please start with the lecture. Over to you, sir.
Let's get on with the lecture. Good evening, everybody. We are all here to have a discussion on the practice and procedure paper for upcoming AOR examination. So, as a prelude, I must say, with limited time at hand, I try to give as broad a picture as possible of this paper. But it may be able to discuss each and every provision of the Constitution, the Supreme Court Rules 2013, and other relevant statutes. So our joint endeavor today, friends, should be to broadly try and understand the functioning of the Supreme Court and additionally discuss some situations arising frequently, which you may otherwise not be able to think on bare reading of the rules and revisions. However, they may still be asked in the examination. So that I should make you understand the broad contours of this paper. I have also tried to include some recent judgments on some issues, which you can always ask questions based on them. So you will all do well in articulating your preparation on other recent judgments also will come across. And please note that this is true not only of practice and procedure, which we will discuss today, but also of your other paper drafting in the AOR exam. Now, what we have done at the office, and I have also done some research on the practice and procedure papers of the last few years. They are available on the site of the Supreme Court. So we have tried to specifically cover as many aspects as possible from the last year's question papers. Still, syllabus requires in-depth knowledge of each and every rules and the Constitution of India, as also substantive lot of statutes, so of which we may not be able to touch today in this discussion. The examiner, in my opinion, expects you to almost cover the rules and the Constitution provisions. So I've also realized that well in this, not only have you to be well versed with the procedural aspects of the Supreme Court, but also substantive law aspects. So it has much more to do than the title of the paper suggests. So let us now begin with examining the provisions of the Constitution of India first, as are relevant for the paper of yours. Alongside, it will be my endeavor to apprise you with the relevant Supreme Court rules and some related aspects, judgments, etc. So we'll begin with Article 124, which is in Chapter 4 of the Constitution. It provides for establishment and constitution of the Supreme Court. It provides that it shall have the Chief Justice, and presently 33 other judges are provided for. The procedure for appointment of judges has been quite in news in the recent years, and you would all be well advised to go through the judgments in the first judge's case, which is SP Gupta of the year 1981. The second judge's case, which is Supreme Court AOR Association. So our AOR Association has been doing a fantastic since the year 1993. In that judgment of 1993, the collegium system was introduced by saying that the Honorable Chief Justice and 2 senior judges would be the collegium for selection of judges. Then comes the third judge's case, which is called in re appointment and transfer. It was a reference by the Honorable President. It came in the year 1998. So what it did was that the collegium became Honorable CJI and 4 senior judges, and the 4th judge case, which is the Supreme Association versus Union of India 2015, by way of which the 99th Constitutional Amendment of 2014 and the National Judicial Appointments Commission Act of 2014 were declared constitutional. So this is about the appointment of judges.
Gagan sir, sorry to disturb. आपकी ना voice crack कर रही है थोड़ी सी, crack कर रही है सर थोड़ी सी. I'm getting messages here. Your voice is getting cracked actually.
Give me a moment.
There's an issue probably.
Some internet issue. So just check please.
It will not come now. Is it okay now?
Ha.
So shall we restart?
Yeah, sir. It will be better.
Please, sir, please.
Okay. Is the voice all right now?
Yes, sir.
Okay. So now I have been told that the voice was cracking and I just kept speaking. So I am starting once again. I will start with the prelude which I gave, which was that it will be our endeavor to give you a broad picture of this paper. It may not be feasible to discuss each and every provision of the Constitution and the Supreme Court rules. So our joint endeavor today should be to broadly try and understand the functioning of the Supreme Court and discuss some day-to-day situations which arise frequently, which we may not be able to otherwise think of after a bare reading of the rules and the provisions. However, they may be asked in the examination. So I hope that I should make you understand the broad contours of this paper. We have also tried to include some recent judgments on some issues, which you can always expect to be asked in the examination. I would advise that after this lecture also, please articulate your preparation on other recent judgments which you may have come across relevant for this paper. And please note that this is true not only of practice and procedure, which we will discuss today, but also for your other papers, particularly the drafting paper. So what we have always done is that we have researched the practice and procedure paper of the last few years. They are available on the Supreme Court website. And we have specifically tried to cover as many aspects as possible in today's lecture. However, friends, the syllabus, as I have seen, requires an in-depth knowledge of each and every provision of the Supreme Court rules and the Constitution of India, as also substantive law, which is part of a large number of statutes. So we may not be able to touch all of that in today's discussion. It is my endeavor to still provide you a comprehensive outlook of this paper. So far as I have seen, the exam pattern expects you to almost cram up the rules and the Constitution. So please do that. I have also realized that to do well in this paper, you don't only have to be well versed with the procedural aspects, but also the substantive law aspects. I will give examples during my lecture. So it has much more to do than the title of this paper, practice and procedure, actually suggests. So please do a lot of hard work and then you'll be able to crack it. Now let us now begin with examining the provisions of the Constitution of India first, which are relevant for this paper. Alongside, it will also be my endeavor to apprise you with the relevant Supreme Court rules and some other related aspects, some recent and old judgments, etc. Since we are talking about the Supreme Court, let's start with Article 124, Chapter 4 of the Constitution, which provides for establishment and constitution of our Supreme Court. So it says that it shall have the Chief Justice, and presently it says 33 other judges. Now the procedure for appointment of judges, we should know for this paper. This has been quite in news in the recent years. So you would be well advised to go through the judgments, which are as follows. So the first judgment you should see is the first judge's case, which is called SP Gupta of the year 1981. Then came the second judge's case, which is called Supreme Court AOR Association versus Union of India 1993. That in fact introduced the collegium system for appointment of High Court and Supreme Court judges. And it mentioned that the collegium would have the Honorable Chief Justice of India and 2 senior-most judges. Then came the third judge's case, which is called in re appointment and transfer. Now, it was a presidential reference under Article 143. And the only difference which came about was that the collegium system became the Honorable Chief Justice and 4 senior-most judges. Then, of course, comes the fourth judge's case, which is the Supreme Court AOR Association once again versus Union of India 2015. So all of you must thank the Supreme Court AOR Association for the system which has developed over the years for appointment of judges. So by way of which this 2015 judgment, the 99th Constitutional Amendment of 2014 and the National Judicial Appointments Commission Act of 2014, they were declared unconstitutional. So the power remained with the collegium. So this was about appointment of judges to our Supreme Court. Now, moving on, we shall discuss the various jurisdictions the Supreme Court of India exercises. This will be important. So I would want to go in chronology in which they appear in the Constitution, and then we'll alongside discuss the relevant Supreme Court rules. And in fact, all of you can keep the Constitution and the Supreme Court rules handy for a better understanding. Since Article 129 is the first article in chronology, we'll start with that. That, in fact, is the contempt jurisdiction of the Supreme Court. It says that the Supreme Court shall be a court of record with power to punish for contempt of itself. So this you have to read alongside Contempt of Courts Act 1971 and the rules to regulate proceedings for contempt of the Supreme Court. These rules are always part of the Supreme Court rules. If you have a Bare Act, they are always there at the last part of the rules. So a court of record, at times the question arises, what is a court of record? So the court of record, to my understanding, is a court whereof the acts and judicial proceedings are enrolled for a perpetual memory and testimony. These rolls are called the records of the court and are of such high and eminent authority that their truth is not to be questioned, and which has power to fine and imprisonment for contempt of its authority. So you'd find in the Contempt of Courts Act that the learned trial courts may not have contempt jurisdiction except say 39(2)A CPC, and they'll have to refer their contempt to the Honorable High Court. So they're not courts of record. High Court and Supreme Court are courts of record. There have been questions in the past, in your examination paper, I mean, about contempt and its facets, such as what is civil contempt, what is criminal contempt. So all of you will do well to study these provisions in detail. Now, next jurisdiction we would like to discuss at some length is the original jurisdiction of the Supreme Court. Article 131 is the relevant article for this of the Constitution. It talks about disputes between Government of India and one or more states, or Government of India plus one state on one side versus one or more states on the other side, or between 2 or more states. So this procedure for the Supreme Court for these suits is prescribed in Orders 25 to Order 37 of Supreme Court Rules 2013. Now they are similar to CPC. However, there are judgments which say, I'll deal with them in next few minutes, which they say that they are not to be tried as suits per se in CPC, but guidance is to be taken. So the classic judgment you all may note down on the scope of this jurisdiction is 1977 4 SCC 608, State of Karnataka versus Union of India. It's a 7 judges bench decision. Now please take out 2024 8 SCC 767, State of West Bengal versus Union of India. Now just pausing here for a bit, as I have told you in the initial part of my lecture, recent judgments, the examiners of the AOR exam, from what I know, are very fond of asking questions from recent judgments. So you should have a recent judgment on almost every aspect. On this aspect, we could find for you 2024 8 SCC 767, State of West Bengal versus Union of India. It's a judgment dated 10th of July 2024. Now, in this judgment, you will find that all the other judgments, such as State of Rajasthan versus Union and Union versus State of Rajasthan, the 1984 judgment, they are all mentioned. And the Supreme Court in this 2024 judgment has held that Article 131 is attracted only when a dispute arises between or amongst the states and the Union. It has to be in the context of the constitutional relationship that exists between them and the powers, rights, duties, immunities, liabilities, disabilities, etc. flowing therefrom. So you must read these judgments in detail, especially the 2024 one, and you can expect a question from them so that you are able to answer them effectively. Now, the Honorable Supreme Court in this judgment has held that the important aspects of the original suit jurisdiction are that such a suit does not contemplate any private party being arrayed as a disputant on one side or the other. Any legal right can be enforced by a suit in the Supreme Court, provided the parameters mentioned in clauses A, B, and C of 131 are fulfilled. Now, there is always an issue about maintainability of issues which may be raised in such a suit. So the court goes on to say that what is required to be considered is that in determining the maintainability of the suits, whether any legal right of the states is sought to be vindicated or not. It is not essential that the dispute must arise in the context of the Constitution and the federal setup which it provides for. So I'll give you an example of this 2024 judgment itself, because there can be questions as to whether if there is a commercial dispute between two states, should they come to Supreme Court? Whether the dispute should be related to the federal setup, only then can they come to the Supreme Court. So there is no clear answer. However, in this 2024 judgment, it dealt with a preliminary objection. So it's not a final judgment, detailed judgment on the preliminary objection. The issue was that whether after withdrawal of consent under Section 6 of the Delhi Special Police Establishment Act, which is the parent act for CBI, CBI through the Union of India, can it continue to register and investigate cases in violation of the provisions of Section 6 of the DSP Act. So the state of West Bengal has come to the Supreme Court. The union raised an objection, but the court held that the suit is maintainable and it cannot be rejected at the threshold. So this judgment will give you a lot of insight into this Article 131 as to what kind of suits can be entertained by the Supreme Court. Now we move on to the writ jurisdiction. Article 32 is extraordinary original jurisdiction of the Supreme Court. So as we all know, it is the power and jurisdiction of the Supreme Court to grant appropriate writ, direction or order for enforcement of rights under Part 3, more commonly called as fundamental rights. So this corresponds to Order 38 of the Supreme Court rules. Now the rules would always only provide the procedure. So we have to see the substantive law as also the procedure. So the substantive law here is Article 32. Rules are Order 38 of the Supreme Court rules. Now, please note that for writs which are in the nature of a public interest litigation, there is a separate cell which has been constituted by the Supreme Court for scrutiny of such petitions and letters, etc., which are received by the court. So even if you file a PIL on the counter, it will first go to this cell. They will scrutinize it. There is a committee. There are also a set of PIL guidelines on the Supreme Court website. Now, if you see Order 38, it provides for necessary ingredients which must be mentioned in an Article 32 writ petition. And if it happens to be a PIL, there are certain other ingredients which are to be specifically mentioned. So please go through them and almost cram them up, because I have seen that there are questions in the recent past about the specific averments which are mandatory to be mentioned in an Article 32 writ and in a PIL. So you will do well to read these rules and just see what are the averments. So the averments you'll find in Order 38 are that whether the petitioner has a private interest in it, what is he doing in life, etc., etc. So all of that you must mention in the answer corresponding it to the rules so that you get good marks. There is an article called Article 139. So that says, this is just for the sake of completeness of this issue. It says that by way of any law by the Parliament, the Parliament can empower the Supreme Court to issue writs for the purpose other than Article 32 also. So this article, you may note, there can be a tricky question on this. Now, while remaining stuck to the original jurisdiction, a reference is also required to the Arbitration and Conciliation Act 1996. So Section 11, as you all know, provides for appointment of arbitrator by the Supreme Court in matters relating to international commercial arbitration. So High Court would appoint for domestic arbitrations and the Supreme Court would appoint for international commercial arbitrations. Now, although what is international commercial arbitration is defined in the Act, still we have a recent judgment of 2021 where the Honorable High Court erroneously decided an arbitration petition for international arbitration and appointed the arbitrator itself. So if you would want to know how the Supreme Court takes international commercial arbitration, you can go through this judgment 2021 8 SCC 465. So it's called Amway India versus Ravindranath Rao Sindhya. Also, additionally, you should know that there is an appointment of arbitrators scheme. So it is called appointment of arbitrators by the CJI scheme 1996. That governs the procedural aspect of the same, because you will not find them in the Supreme Court rules. So you should not miss it, because arbitration is also one of the favorite topics for the examiners. So please go through this scheme. It will have the nuances of the procedure to be followed if you file a Section 11 petition. Now we are done with the original jurisdiction. We will now come to the main jurisdiction which the Supreme Court exercises in most of the cases, which is the appellate jurisdiction. Now, appellate jurisdiction is very important. It will constitute at least half of your question paper, is what I feel. So we'll start with Article 132 and go on until Article 136. So 132 is to be read with 134A of the Constitution. It provides for appellate jurisdiction of the Supreme Court in appeals from High Court. In any proceeding, I will go a little slow now because there is a distinction here. In any proceeding involving substantial question of law as to the interpretation of the Constitution, provided the High Court gives a certificate to the relevant party in this regard. Now, you will find judgments where it has been said that such a certificate is to be granted by the High Court, if at all, only for final judgments and not interlocutory orders. So I am emphasizing certain expressions because there have been tricky questions in the past in this paper. So you should be able to understand what is the distinction. Now, after 132, if you see 133 and 134, they are also to be read with 134A. They talk about appeals in civil matters and criminal matters to the Supreme Court, provided that the High Court gives a certificate that the case involves a substantial question of law of general public importance, and the High Court is of the opinion that the question needs to be decided by the Supreme Court. So what is missing here? What is missing here is questions involving interpretation of the Constitution. That was peculiar to 132. So when you come to 133, it has to be a question of general importance, and High Court should be of the opinion the interpretation of the Constitution has been given a go by. However, in addition to such a certificate, if there is an appeal under 133, it is open for the party to additionally urge that a question of law as to interpretation of the Constitution is also involved in cases like Article 132. So that's the fine distinction. I hope you appreciate this and emphasize in your preparation. Now 133 is for civil appeals. So when we come to Article 134, that provides for appeal to Supreme Court in criminal matters. Now this will have entirely different connotations than the civil matters provided in Article 133. In criminal matters, appeal is maintainable in a situation where, you may note, the High Court has reversed an acquittal order and sentenced the accused to death. The second situation can be the High Court withdraws for trial before itself a criminal case, which happens rarely, but it does happen, and then convicts the accused and sentences him to death as an original court. Or if the High Court grants a certificate under 134A, for grounds, of course, mentioned in Article 132, read with 145. So this is the fine distinction. 132 generally appeals, 133 civil appeals, 134 criminal appeals. Additionally, the Parliament is empowered to confer on the Supreme Court further powers of appeal in criminal matters. So what has happened is, you must make a note of this small act. I think it has only 2 sections. Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970. Now this is in addition to Article 134, which I have just narrated, of the Constitution. So in addition to 134, as per this Enlargement Act, appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding when if the High Court has on appeal reversed an order of acquittal of an accused and sentenced him to imprisonment for life or to imprisonment for a period not less than 10 years. So this addition of not less than 10 years has been added. Or the High Court has withdrawn for trial before itself any case from any court subordinate to its authority, and has in such trial convicted the accused person and sentenced him to imprisonment for life or to imprisonment for a period of not less than 10 years. Now, where does this enlargement jurisdiction come from? For the sake of completeness, you should also see sections 374 and 379. These are CRPC sections. The new ones will be 415 and 420 of the BNSS. We are talking about CRPC. So you may read these also, then you will find a correlation between these articles, this Enlargement Act and CRPC. Now, there is a judgment which I want all of you to go through, because there have been questions on this judgment which pertain to this jurisdiction which I have explained. So this judgment, please make a note. It is 2019, volume 20, SCC 143. It's called Rajendra Diwan versus Pradeep Kumar Ranibala and others. It's a constitution bench judgment. There was a section 13, subsection 2 in the Chhattisgarh Rent Control Act, 2011. Now that section somehow provided for a direct appeal to the Supreme Court against an order of the Rent Control Tribunal. So the rent controller would hear the eviction petition, appeal would go to Rent Control Tribunal, and then the state legislature provided that appeal against that will come to the Supreme Court. So the vires of that section was considered by the Supreme Court, and it was held that the state legislature, which is the state of Chhattisgarh in this case, it does not have legislative competence to enact a law to provide for statutory appeals directly to the Supreme Court from the orders of a tribunal. So if you would recall, I had started with my lecture by saying that at times articles you can read, but you cannot envisage situations in which those articles will be used in the Supreme Court. So this is one example of that the interpretation of 132, etc. came up in such a situation where the court had to consider the vires of the section itself providing for appeals. So this judgment is a must read. There have been questions based on this judgment. You may also note 2007, volume 3, SCC 720, which is Sanjay Singh versus State of UP, which says that final judgment of a high court can be challenged only by an appeal to the Supreme Court under Articles 132 to 134 or by special leave under Article 136. So what it meant was that you cannot come under Article 32 by way of a writ petition. So this also you may make a note. There is another judgment which we've taken out, which is 2017 7 SCC 694. This is Agni Gandala Venkata Ranga Rao versus Indukuru Ramachandra Reddy. That says that as per Article 133(3), certificate cannot be granted by a single judge of the High Court. The logic is from a single judge, it should go to the division bench first. So you cannot grant a certificate to come to the Supreme Court. Such a certificate granted by the single judge was revoked by the Supreme Court, and the matter was heard as an SLP under Article 136. So friends, there can be questions after questions. So there can be a question that what happens if a single judge grants a certificate under Article 133? Please answer, and please also answer what should be the remedy. So this judgment will give you that answer. It will open your eyes as to what can be the remedy in such a case. You may then also make a note of 2003 volume 8 SCC 50, which is State of Gujarat versus Salim Bhai Abdul Ghaffar. This also lays down that if on the face of it, Supreme Court is satisfied that the High Court has not properly exercised its discretion in giving a certificate, and that the High Court should not have given the certificate, that also is challengeable in the Supreme Court, and the Supreme Court can either remand the matter or treat the certificate as having been nullified and proceed under Article 136. Now, again, for completeness, there are some corresponding sections for such appeals in CPC also, which you may note. These are sections 109 and 112. So that will make a complete scheme, and the corresponding rules in the Supreme Court rules are the orders 19 and order 20 for these appeals, 132 to 134A. Now we come to extraordinary appellate jurisdiction, the favorite article of all of us. This is Article 136. Now I must advise that the classic case which you must go through for understanding the scope of jurisdiction of 136 is a 70-year-old case called Durga Shankar Mehta versus Raghuraj Singh. It is 1955 1 SCR 267 Constitution Bench judgment. It was held that the powers given by Article 136 are in the nature of special or residuary powers which are exercisable outside the purview of ordinary law. There can be cases where needs of justice demand interference by the Supreme Court. It is a plenary jurisdiction of the Supreme Court that by grant of special leave, court can hear any appeal against any kind of a judgment by any court or a tribunal. Now, of course, that does not mean that the hierarchy is to be jumped in every case, but the court has power, and I'll explain to you by way of judgments as to how this power has been exercised by the Supreme Court. While normally we should maintain the hierarchy is what I want to emphasize. The procedural aspects of Article 136 I need not emphasize are the orders 21 and 22 of the Supreme Court rules. Now, as I keep saying that you should know about some recent judgments, you may make a note of this 2025 SCC Online Supreme Court 291. This is called Om Prakash Gupta versus Satish Chandra. So although this judgment has come recently, but what it lays down, I have found some questions pertaining to this in the earlier years of your question papers. So please make a note of this judgment. It says something very important. So it says that even though an order is not under challenge before the Supreme Court, there is no bar for the Supreme Court to erase defective orders from the record by setting them aside even in the absence of any challenge. So which means that the Supreme Court has powers to make any order to cure a manifest illegality and to avoid travesty of justice in the absence of even a challenge to such order. The Supreme Court has used another expression, and which is molding of relief. So it says that the court, while entertaining an appeal by grant of special leave, has the power to mold relief in favor of the respondents, notwithstanding the fact that no appeal has been filed by them challenging that part of the order. Because the petitioner would have challenged the order, the respondents have not challenged the order. Still, the court says that we are empowered to mold the relief if there is an obvious error of law against the respondents who may have otherwise won the matter. So it says that Supreme Court can even exercise a suo motu power in Article 136, which is very important. Now, there is another aspect which is often asked, and it often arises also in the court, and you should know, which is the doctrine of merger. When we talk about Article 136, the important aspect is that what is the precedential value of a limine dismissal order passed in an SLP under Article 136. So normally you would see that you argue an SLP and the order comes heard, no merit, dismissed, etc. and various forms of this order. So the classic case on this subject is Kunhaiya Med versus State of Kerala. This you can make a note. 2000 volume 6 SCC 359. So you'll have to read this judgment because we have some limited time today. I may not be able to explain to you in detail, but this judgment is a very simple read and a must read. So the doctrine of merger and the jurisdiction of the Supreme Court at SLP stage and the jurisdiction post leave being granted is explained in this judgment. So this came to be approved in 2019 for SCC 376 Khode Distilleries versus Shri Mahadeshwara Sahakara Sakare Karkhane Limited. Now, all these judgments reflect upon the often arising riddle, which is, there's another riddle after the in limine dismissal. The riddle is, what is the scope of a review petition in the High Court once an SLP is dismissed by the Supreme Court? So therefore, once you read these judgments, you'll have answers. There can be so many situations. There is no yes or no here. You have to go through these judgments. These judgments have to be studied. These are important part of practice and procedure. Historically, I am expecting at least one question from this, from my experience, and one of the favorite topics for the examiners once again. Now, there is another aspect, friends, which I want to inform you about today, which can be asked, is that you please note this judgment. It's called Biswajit Das versus CBI, 16th January 2025, and the citation is that 2025 SCC Online SC 124. Now, another practical situation. At times, when you argue an SLP, Supreme Court says issue notice limited to mediation or issue notice subject to only reduction of the sentence, imprisonment, nature of sentence, etc. So normally one would feel that once Supreme Court has issued limited notice, the door is now shut for me. This is what all of us perhaps feel. So now this judgment has come. There are, of course, earlier judgments also, but this is latest. You must go through this. And this says that even if Supreme Court issues limited notice on day one of the hearing, but you are able to convince the court at a later stage that this order needs to be recalled and the notice is to be enlarged, then Supreme Court has the power and jurisdiction to do so. And you have a right to ask for this at the behest of your client. If there is a question in the paper, I think you must answer it by saying that by way of this judgment, The Court has now held and not held rather reiterated that the notice, if limited at the first stage, can always be enhanced. However, you must file an application praying for such enlargement and also giving out necessary ingredients as to why. So it cannot be a routine exercise that in every case you file this, but if you feel that it should be enlarged, especially in the criminal cases or in cases where only mediation notice has been issued initially, you can take your chance. Normally people are not aware of this, so I thought I must bring it to your notice, and you can also expect a question on this in the examination. A similar aspect is condonation of delay. So if as a respondent's counsel, you are shown a notice which contains the first order of the court in which it has been said that issue notice, delay condoned. So normally one would feel that now delay has been condoned and it is beyond our purview to challenge it. For that, please note a judgment, DDA versus Tejpal. Again, this is recent, 2024-7 SCC 433. So this places reliance on Order 21, Rule 9. This rule of the Supreme Court rules. So this rule says that court should not condone delay ex parte. However, the Supreme Court in this Tejpal judgment has now held that even if it is condoned ex parte, it will not be fatal in the subsequent stage. However, the respondent has the power and the right, when it appears and files a counter, it can also pray that, see, you condoned the delay erroneously, so please hear me on the delay and recall your order. So these are 2-3 situations which frequently arise. They may ask you a question in the paper that suppose delay is condoned and you are contacted by the respondent in this matter, what will you do? So if the delay is inordinate, the delay should not have been condoned, the door is not shut. So this theory is door is not shut. You can look at Order 21, Rule 9 of the Supreme Court rules and Para 76 of this Tejpal judgment, right? So now this is about Article 136 and some day-to-day features of this article. Now I will quickly move on to review and curative jurisdiction of the Supreme Court. Article 137 is the exercise of review jurisdiction of the Constitution. Order 47 in the Supreme Court rules are the procedural aspects. It falls back upon the review in CPC, which is also Order 47 coincidentally. The grounds are the age-old adage grounds, discovery of new and important matters or evidence, error apparent on the face of the record, or any other sufficient reason. So for curative, you please see Order 48 of the 2013 rules. Again, I would like to share with you some recent judgments. So for review, you may make a note. There is this judgment called Siddham Sethi Infra Projects versus Kattha Sujata Reddy, 2024 SCC Online SC 3214. Now, I cannot emphasize more that whenever you are asked a question, if you spice it up with a judgment, you will always get better marks. You can take it from me. So even for a simple topic like review, suppose you would cite this judgment, which is a recent judgment, the examiner would feel that you've done a lot of hard work. So this judgment gives an insight into necessary ingredients for a review in the Supreme Court of India, and this judgment allowed the review, right? Now, another aspect which is coming up frequently, which I see in the court, is filing of miscellaneous applications in disposed of matters. So there can be a question on this also, because this has been debated recently, because there is this tendency of filing MAs after MAs in disposed of matters. And why? Because the review would go in the chamber. Nobody wants to file a review because it goes to the chamber, you don't get a hearing. So because of this growing tendency, there have been judgments also. You may make a note. There is this judgment called Gagan Banga versus State of West Bengal, 2024 SCC Online SC 2608. Now in this, the position in the earlier judgments was reiterated. This is nothing new. It just compiles all the earlier judgments. This is Justice Kaul's judgment. And it is lamented that it is to avoid review that applications like clarification, modification, and recall are filed so that somehow you get a hearing in the open court. However, the Supreme Court again has not shut the door on these applications. It has said that if individual facts of a particular case so warrant, there cannot be a bar to entertaining such a petition in a disposed of matter. So you can go through this judgment. It has given situations where this application can be entertained. So if there is a question, you can add it up by this judgment. Of course, it depends on facts and circumstances of each case. The provision which lawyers use for filing such MAs is the inherent power, Order 55 Rule 6 of the Supreme Court rules, right? So that you may go through. Court has held that there should not be any abuse of process. So if your application is short of abuse of process, it shall be taken up. Now, you will also do well, for the sake of completeness, to go through. There is a circular dated 3rd of January by the Supreme Court Registry with the approval of the Honorable Competent Authority about filing of the miscellaneous applications. So it says that if the application is not under Order 12 Rule 3, which talks about a typographical error, or Order 16 Rule 4, which is dismissed in default, meaning that these two situations, of course, the application should be entertained. But if there is an MA beyond these two situations, clerical error or DID, then you are to specifically aver on oath that filing of the MA has been necessitated because the order passed in the main proceeding is executory in nature. This is the language of the circular. And it has become impossible to be implemented because of some subsequent events or developments. And you have to make such a declaration on solemn affirmation. So I suspect that this day-to-day growing tendency of filing MAs can attract one of your examiners for this paper. And if there is this question, you can cite this circular and this judgment of Gagan Banga. Curative, we are still left with. So it can also be a star component of your paper. There has always been a question on curative from my reading of the last few papers. So of Rupa Ashok Hurra, of course, everybody must be aware by now. It is 2002, Volume 4, SCC 388. That's the judgment which created this remedy of curative. And it gave a very limited scope. However, now there is a recent judgment which you may note, which is DMRC versus Delhi Airport Metro Express Private Limited. The citation is 2024 6 SCC 357. So now, in addition to Rupa Hurra, another ground has been carved out, and which says that while deciding a curative petition, jurisdiction of the court extends to cases where the court has acted beyond its jurisdiction, resulting in a grave miscarriage of justice. So the scope has been expanded. How it is practically applied, of course, is another matter. But this judgment should be mentioned in any question which you may get on curative. Now, there is also another practical situation. What is the limitation for a curative petition? So the court has held in this judgment 2024-9 SCC 637 called Brahmaputra Concrete Pipes versus Assam State Electricity Board. Two things. One is that you cannot equate curative petition limitation with a review petition. It cannot be 30 days. It has to be a reasonable time. So there is no limitation as such, but there should not be any delay or laches. And that what is the maintainability of a particular petition, the learned registrar cannot decide. He cannot reject sitting in his chamber. So he has to send it to the court. It must have been an instance where the registrar himself said that curative is not maintainable, etc., out of delay or some reason. So please go through this judgment and keep it. Now, there is another very, very typical jurisdiction of the Supreme Court. It's called enlargement of jurisdiction by Article 138 of the Constitution of India. You can go through the article. We are running out of time. I will give you this judgment, 2016-9 SCC 103, called Gujarat Urja Vikas Nigam versus SR Power. Here, the court held that while there may be no lack of legislative competence with the Parliament to make provision for direct appeals to the Supreme Court from orders of tribunals, but legislative competence is not the only parameter of constitutionality, and the Parliament should not clog the Supreme Court with such appeals. So it has said that we are deprived of time for important matters when such commercial matters, these are all tribunals mostly are service matters or commercial matters, right? So court said that we are lamenting that direct appeals are given to us. The Law Commission was directed to look into this aspect. Then the Law Commission, after this judgment, has given a report. That's report number 272 of the year 2017. It has recommended that every order emanating from a tribunal or its appellate forum attains finality, and if appeal, if any, has to be provided, that should go to a division bench of the jurisdictional high court. However, Parliament is yet to take a decision as per our research. So the issue remains there. Nonetheless, there are many statutes which provide for direct appeals. So when I said in the initial part of my lecture that substantive law is also important, so you should know some of the acts we have pulled out. Section 38 of the Advocates Act, which corresponds to Order 23 of the Supreme Court rules. Then you have a direct appeal in the Consumer Protection Act, provided the NCDRC is hearing a consumer complaint, which is Order 24 of the Supreme Court rules. Then we have direct appeals in the SEBI Act, TRI Act, Competition Act, Electricity Act, Armed Forces Tribunal Act, NGT Act. So you go through the provisions of this act wherever it pertains to appeal to the Supreme Court. Any of this question perhaps is in the zone of probability of being asked. Then we quickly move on to the transfer jurisdiction of the Supreme Court. Article 139A provides for transfer of certain cases on given parameters. So these are cases which are filed against any state or a union. There are similar cases filed in different high courts. Some may have been in the Supreme Court directly. So this article provides for transfer to so-called consolidation to either one high court from all the high courts or to the Supreme Court itself. So the general perception was that if the subject matter is same, the Supreme Court would routinely call all these matters to itself. However, there has been a divergence. So the recent judgment which we could find on this is 2022-19 SCC 348. This is called Union of India versus United Planters Association. So this gives a good insight. If any question is asked on Article 139A, you can use this judgment. It says that the likelihood of divergence of decisions cannot be a sole ground for transfer. And transfer petitions, in fact, were dismissed in this case. And the matters were allowed to be proceeded in the different high courts. It was said that they can have different facts, etc. So let the high courts decide. Then Section 25 is a very lovable jurisdiction of the Supreme Court in a little lighter vein. One of those sections which, if you are for the lady and if it's a transfer petition, 99% times it goes through. So this is the lovable jurisdiction called Section 25 of the CPC for civil matters and 446 BNSS. So this was 406 CRPC for criminal cases. The criminal cases transfer jurisdiction is not very successful, but civil cases is almost short. Then orders 39, 40 and 41 of the Supreme Court Rules 2013, they prescribe the procedure for the transfer petition. So you must go through these orders. Article 140 is ancillary powers. I need not dilate on this. Then we come to a very important aspect of the Supreme Court, which is the law of precedent. Now, what is this law of precedent? Article 141, you may note. This is also, like I have been saying, one of the favorite topics for the examiners. Expect a question. This article is multifaceted. It has several aspects to its interpretation. So please make a note quickly. 2025 SCC Online SC 290 Canara Bank versus Ajit Kumar. In this recent judgment, court has reiterated that in view of Article 141, a decision of the Supreme Court is binding on a high court, no matter whether in such decision this court considers all the provisions of law or not. So what they mean is that even if it's an obiter dictum of the Supreme Court, it is still binding on the high courts. This is very important. I am again emphasizing. So you must read these judgments to understand the fine nuances. I may not be able to elaborate here. And however, it has also said that a coordinate bench of the Supreme Court may not be bound by any obiter dictum or any principle laid down in an earlier decision if it does not have the occasion to consider a particular issue of law. So that's called per incuriam. You may also now go through a very good judgment which has been recently passed, 2025 3 SC 440. This is called NBCC India versus State of West Bengal. Now here the Supreme Court, speaking through Justice Narasimha, has second thoughts about interpretation of Article 141. And thus this judgment becomes very important for your syllabus. Now it has been held in this judgment that as an institution, the court performs twin functions. One is decision making and the other is precedent making. So it was observed that every judgment or order of the Supreme Court may not be intended to be a binding precedent under Article 141. Because what happens is, we would cite the judgment before the High Court and the learned trial courts and say that this is Supreme Court, even if it's obiter, you are bound by it. So High Courts and subordinate courts face difficulty in determining whether the judgment is in the process of decision making or precedent making. I am quoting from this judgment, Justice Narasimha's judgment. So therefore, court says that it is necessary for the Supreme Court to be cautious in their dispensation and specifically state whether a particular decision is to resolve the dispute between the parties to that case, to provide finality to their dispute, or whether the judgment is intended to and in fact declares the law under Article 141. So this is important. In the facts of that case, it was referred to a larger bench. So you can see if it has been decided or not. I think it is pending. Now, another aspect which you should know is a slightly detailed aspect. I'll just quickly take you through it. AR Antule is the premier judgment on this, AR Antule versus RS Nayak, 1988 to SCC 602. This is about hierarchy and judicial discipline within the Supreme Court. So in some countries, we have this concept that the size of the bench does not matter. But this judgment started the trend by saying that in Supreme Court, size matters. Smaller benches are bound by larger benches, and larger benches can overrule smaller benches. So you must go through this judgment. And there are several others. I will just cite very, very quickly, because this is a tricky topic. You can expect, I think, a question from this also. This is always a very tricky topic. How a bench should refer the matter to a larger bench. What is the procedure to be followed? So this is also one of the legal riddles. The few judgments which I would like you to note. One is Bharat Petroleum versus Mumbai Shramik Sangha. This is 2001, Volume 4, SCC 448. Now that holds that decision of a constitution bench of the Supreme Court binds a bench of 2 learned judges, which means that 2 learned judges cannot say that the constitution bench judgment is wrong, and that judicial discipline obliges them to follow the constitution bench, even if they have doubts regarding its correctness. So it also provides for a remedy that the division bench, the 2 judges bench, can order that the matter be heard by a bench of 3 learned judges if they feel that there is some error in the constitution. They cannot say that I will disregard. Then please note Pradeep Chandra Parija versus Pramod Chandra Patnaik. This is 2002, 1 SCC 1. It says that 2 judge benches may also must also follow the precedent of 3 judge benches, not only constitution bench. That only in cases where 2 judges determine that a 3 judge precedent cannot be followed under any circumstances, and then they can refer the matter, of course, to a larger bench. But they're also only to a 3 judge bench and not directly to the constitution bench. So if the second 3 judge bench to which they refer the matter agrees with the assessment of the referring bench, which was a 2 judges bench, then that 3 judges bench will refer the matter to a constitution bench, right? Now you please note Central Board of Dawoodi Bohra Community versus State of Maharashtra. This is 2005 to SCC 673. This also says that decisions of larger benches are binding on benches of equal number, and a smaller bench cannot doubt the correctness of a larger bench's opinion. It can only refer the matter to a bench of larger quorum than the bench whose decision has come up for consideration. However, there is a caveat that Central Board judgment, the Central Board of Dawoodi Bohra Community, allows the Honorable Chief Justice of India to use his discretion and direct references to be heard by benches of any size. Now, 2 judgments which have been recently rendered are important, because I would keep emphasizing recent judgments do attract the examiners, and you should know. On this aspect, please go through the minority judgment of Justice Bela Madhurya Trivedi in 2025, 1 SCC 1, State of Punjab versus Devinder Singh, and of Justice B.V. Nagaratna in 2024, 10 SCC 1, Mineral Area Development Authority versus SAIL. Of this judgment, I could quickly take out the paras for you, which is para 520.3 and 520.4. So these you can read and you will understand all the aspects which I've just tried to elaborate. There is another very interesting aspect which I realized when I was preparing for this lecture. And note this judgment. This is Trimurthy Fragrances versus GNCT. So this is 2022 SCC Online Supreme Court 1247. Again, a constitution bench. A hypothetical question came up that what was the, if the basis of a ruling, a 7-judge ruling comes by a 4:3 majority. Now listen to this. 7-judge judgment comes by a 4:3 majority, but it wants to overrule an earlier 5-judge bench, which was actually 5:0. So all 5 judges of the constitution bench were in unanimity. So then it says that hypothetically the result becomes 4:8, because they are a 4:3. The present 7-judge is 4:3. The earlier they want to contradict is 5. So 3 plus 5 becomes 8. They remain 4. So then Justice Indira Banerjee, speaking for the bench, noted that such a net vote would be irrelevant since the 4:3 judgment is by a larger bench. So the larger bench's judgment would rule the day over a smaller bench, regardless of how the 2 benches voted in tandem. So this is very interesting. It can be asked in a question paper, I expect, either the drafting one or this practice and procedure one. Now quickly to the rules. Order 6, Rule 1 of the Supreme Court rules talks about constitution of the benches. It says that every cause shall be heard by a bench consisting of not less than 2 judges. Rule 2 provides for constitution of larger benches. Rule 6 provides for powers to the learned single judge to hear matters in vacation, even if they are otherwise to be heard by a division bench in working days. Now, it is important that with passage of time, these vacation bench matters for which the learned single judge had jurisdiction, they have been given to, you must all be aware, they have been given to learned single judges in normal working days also, like issuance of notice in fresh TPs. So please keep this in mind. There can be a tricky question about this also. And the minimum strength of constitution bench has to be 5. That you will find in Article 145(3) of the Constitution, right? Now, let's quickly come to plenary jurisdiction, Article 142, which is the complete and absolute power of the Supreme Court to pass necessary orders. All of you are aware of this article. I need not dilate too much on this. I just want to bring to your notice one judgment, because we should not misunderstand this Article 142. This is 2023 10 SCC 232 Union Bank versus Rajat Infrastructure. Now, the popular perception can be that in 142, the Supreme Court can pass any and every order which it may like. However, it is not so. So this judgment elaborates to say that while passing an order under 142, the court cannot ignore any substantive statutory provision dealing with the subject. Now, this as a corollary would necessarily mean that the court cannot pass an order in 142 which otherwise is not made out in law. So this is also sort of a riddle, but you have to keep in mind that if there is a question, there have been questions on this. So you don't have to say that 142 court can do anything and everything. You must say that it has to do whatever it wants to do within the parameters of law, within the different statutes governing the dispute before the court in that matter. So although the powers are of a wide amplitude to do complete justice, but they cannot be used to supplant the substantive law applicable to the case. Correct? So this question, now I'm grateful to my office. They told me that this was specifically asked in the 2021 AOR examination. So this is important. Then we come to advisory jurisdiction of the Supreme Court, right? So this is Article 143. The Honorable President can consult the Supreme Court. There is a recent controversy. All of you are aware of it. So it might interest your examiner also, and there can be a question. Her Excellency, the President, Draupadi Murmu ji, has asked the Supreme Court a very pertinent question, whether governors are bound to act on the advice of Council of Ministers when a bill is placed before them under Article 200 of the Constitution. Now, this is interesting because it comes a month after the Supreme Court's landmark verdict, in this case filed by the Tamil Nadu government. The citation is 2025 INSC 481, State of Tamil Nadu versus Governor of Tamil Nadu and others, Justice Pardiwala and Justice Mahadevan. The relevant rules for this procedure are Order 42 of the Supreme Court rules. You may also note another article, which is 317 of the Constitution. So the Honorable President, beyond what is mentioned in 143, can also ask the Supreme Court to hold an inquiry against a chairman or any other member of a public service commission. And if Supreme Court returns the inquiry by saying that the concerned chairman or member is guilty of misbehavior or say misconduct and ought to be removed, then the president may order accordingly. So that's the process for removal of a chairman or a member of a public service commission. Order 43 of the Supreme Court rules is relevant. Then there is an Order 44, which also provides for procedure regarding reference made by the central government, not just the president. The central government or any statutory tribunal can also make references to the Honorable Supreme Court. And you will find these provisions for sending a reference to the court in Companies Act, Right to Information Act, Competition Act, and Prasar Bharati, which is the Broadcasting Corporation of India Act, right? And there is an Order 45 in the Supreme Court rules, which talks about references under Section 257 of the Income Tax Act 1961. So very quickly, I will request all of you to not only see the Supreme Court rules, but also these substantive statutes which provide for such a reference. So that will be for your better understanding and better answering of the question if there is a question in this. Now, there is also a question in many of the papers of last few years regarding this jurisdiction, the advisory jurisdiction, as to whether the Supreme Court is obliged to give its opinion, right? The answer lies in Article 143 itself. So you just have to read and quote it in the question paper in the answer if it comes. Article 143(1) is the discretionary consultation, which means that the president can refer a legal or factual question to the Supreme Court. It applies if the matter has arisen or is likely to arise and holds public importance. So the Supreme Court may choose to give its opinion or decline the reference. So on the other hand, 143(2) is mandatory opinion on certain disputes. The question which can be asked by Honorable the President has to fall back upon the proviso to Article 131 for a 143(2) reference. Now, these matters are pre-constitution treaties, agreements, or similar instruments. They're mentioned in the proviso to 131. In such cases, if the reference comes, the Supreme Court must give its opinion after holding a hearing. Now, there have also been questions on the binding authority of such a reference and its answer by the Supreme Court. So the answer which I could call out is that the Supreme Court's opinion under 143 is not legally binding on Honorable the President. The Honorable President may either accept or reject the advice. In the same breath, I must say that Article 143 does not allow Honorable the President to appeal or revise Supreme Court judgments. It serves only a consultative role and does not function as an appellate provision. Now, the Supreme Court, like I said, 143(1) is discretionary of the Supreme Court. There can be a question as to on what grounds can the Supreme Court refuse to answer a reference given by the Honorable President. So quickly, the grounds are if the question has already been decided by the court in a previous judgment, if the question is too broad, abstract, or hypothetical, if the issue is purely political and not justiciable, and if there is an attempt to review the judicial decisions, which means that if the reference is to be seen as an attempt to review or overturn an existing Supreme Court decision, that may not be permissible via Article 143. So when I said the recent controversy, I don't want to say too much. You can think about this ground of refusal by the Supreme Court if the examiner asks you a question and you have to formulate your own answer. Lack of constitutional relevance is another ground on which the Supreme Court can refuse. So I will also give you 2-3 cases where the reference was refused by the Supreme Court. That's one is Ram Janmabhoomi Babri Masjid reference of 1993. The court said that the question is unnecessary, not conducive to the resolution of the dispute. And then the Kashmir Resettlement Bill reference, where the court refused to answer the reference relating to J&K grant of permit for Resettlement Bill 1980, because the matter at that time was already under judicial consideration. Now, Article 145 is just to be mentioned. It's the power of the Supreme Court to make rules. The rules we have discussed today at length. Now, the next topic is power of the registrars, the Honorable Chamber Judges, and the learned single judges. Frequently, these questions are asked. So you will almost have to cram, all these provisions. Order 5 of the Supreme Court rules are for business in chambers, where Rule 1 provides for what the Honorable Registrar can do. Rule 2 provides for the powers of the learned single judges. And Order 6, Rule 6, like I mentioned a few minutes back, power of single judges during vacations. And many such powers have now been given to the learned single judges. This has come after the Supreme Court rules 2013. So you will not find this in the rules. The only example I can give is issuance of notice in fresh TPs, etc. So that has been given to the learned single judge. Now there is this election petition jurisdiction. I will now go a little fast. I am conscious of the time. Election petition jurisdiction is Order 46 of the Supreme Court rules. It provides for procedure under election petitions under Part 3 of the Presidential and Vice Presidential Elections Act 1952. That you should know. Then one slightly sensitive issue which can be asked in the examination, I feel, is master of the roster issue. Who is the master of the roster? The answer is obvious, the Honorable Chief Justice of India. A very strict examiner can put you through to this question. For an answer, you may just make a note. SP Gupta versus Union of India, 1981, supplementary Supreme Court cases 87. It refers to the Honorable Chief Justice as a collegium. It is known as the first judge's case also. We discussed that in the initial part of the lecture. Then I think the final judgment should be 6th July 2018. Shanti Bhushan Saab, the late Shanti Bhushan Saab versus Supreme Court of India, 2018, 8 SCC 396. It settled the issue. It should be read comprehensively. There can be a question because if you would have recalled, Justice Oak in his retirement speech has said that the Supreme Court should not be CJI centric. They can have their own views, all of them. So as a candidate, you should be ready for a question on this. The Supreme Court in this 2018 judgment refused to declare that the function of allocating cases and assigning benches should be exercised by the collegium of 5 senior judges instead of the Chief Justice of India. So it reiterated and re-emphasized the situation that CJI and nothing more when it comes to the master of the roster. Then legal aid and mediation, all of you know, that is also one very important aspect. Legal aid, you can refer to the Legal Services Authorities Act 1987 and Article 39A, part of the directive principles of the state policy. So therefore, the Supreme Court of India has now constituted Legal Services Committee, and for mediation, they have also a separate wing called Mediation and Conciliation Project Committee. Now, there is a question asked 2-3 times in the last few years as to what is the effect and binding nature of a mediation agreement signed in the Supreme Court. So for that, I will not say anything, but you can see Kaushalya versus Jodharam 2019-20 SCC 277. Time is short, so I just want to wind up by explaining each and every jurisdiction. Kaushalya versus Jodharam 2019-20 SCC 277. It of course says that the mediation agreements are completely binding and enforceable. Now, there is another important aspect which would not have crossed my mind had I not read the question papers, is the recusal aspect of a particular judge. Now, that necessarily does not relate to practice and procedure, but there have been questions on this. So I thought I'll discuss this in 1 minute. You can go through 2026 SCC 304 Indore Development Authority versus Manohar Lal and others. This is not the dreaded Indore Development Authority. I have a lecture on that also on 29th. But this is a prelude to the same Indore. This only talked about the recusal. So it is a classic judgment on the issue, about 100 pages judgment only on recusal. And it goes on to the extent of holding that a judge who expressed his opinion on a legal issue in a smaller bench can hear the same matter in a larger bench, even if the reference of the same matter is to the same larger bench. So one judge referring a matter to a larger bench then becomes part of the larger bench to hear that reference. The Honorable Judge said, I am not bound to recuse. So please go through this judgment for academic purpose. If there is an issue of recusal, this judgment will cover, it's an encyclopedia on recusal. Now, indigent person, Order 18, you may go through. There have been questions. Order 18 of the Supreme Court Rules 2013. It is important, but the provisions are quite simple. You go through them, you'll understand. Now, I will fail in my duty. Some judgments and some aspects I would like to let you know, because I have seen the papers, very, very detailed, very, very detailed. They can ask you anything from process fee to court fee to limitation to anything at all. Now, all of that, because of lack of time, I am not able to make it part of this lecture, but this is also fairly simple. Again, requesting you to go through all the Supreme Court rules in this regard. Court fee, limitation, process fee also. Even process fee is being asked, that what are the steps will be taken if you are an AOR for a party and notice is issued, you are the petitioner, what are the steps you will take post issuance of notice, etc. Right? So please go through all the rules. Some recent judgments which have come, I will quickly make all of you note all of them. The famous judgment, Supreme Court Bar Association versus State of Uttar Pradesh, 19th March 25, MA number 3 to 4 of 25 in criminal appeal number 3883-3884 of 2024 regarding marking of appearance. So that's a very popular judgment. It led to unprecedented situations, but you must go through it because it discusses the law. Then Jitendra alias Kalla versus State. This is 2025 SCC Online Supreme Court 377. This is a very important read. It can be asked in the question paper. It talks about incorrect statements which come to be made in some petitions. Unique position of advocates on record. This is an AOR examination, so you must go through this judgment, standard of conduct, etc. Then Jasmine Bhai, Bharat Bhai. This is 2025 SCC Online Supreme Court 371. This talks about an important aspect as to when an application for exemption from surrender in a criminal matter needs to be filed and need not be filed. Justice Vikram Nath's judgment, very clear on the subject. So you must go through. This is a frequent question which is asked. Then there is this Harsh Bhuvalka judgment, 2024 10 SCC 790. You'd recall that in the SLPs, you file applications for exemption from filing certified copy. And at times, without even asking the petitioner, averment is made that the certified copy has been applied for in the High Court, but not made available. So the court came down heavily on such applications. And it said that, no, you cannot do this. Either you have to annex the receipt of the certified copy, or you have to file the certified copy itself. So you must go through this judgment, Harsh Bhuvalka. Then there is a judgment called Nandini Sharma, 2023 3 SCC 523, where in fact the petitioner challenged the entire system of the AOR institution, that you don't need AORs in the Supreme Court and there should not be any distinction between AORs and non-AORs. That was, of course, turned down. So that becomes important. 2023-3 SCC 523 Nandini Sharma. Then you must also go through 2021 16 SCC 533. All of you know that two AORs can come together and work as a firm, and they would be known as the firm's name in the records of the court, in the list, in the matters, etc. So the question arose that if an individual AOR can also file and pursue his cases by way of a proprietorship name and not by in his own name, even if there is no partner, so to say. So Justice Call's judgment, it says that there is no bar. When the partnership firm is permitted, there is no bar for an individual AOR to use a proprietary name. However, since the Supreme Court rules don't provide for it, so the Rules Committee has to provide for them, and then it can be done, right? Now, the last sentence is that there is a handbook on practice and procedure, 2017, available on the Supreme Court's website. That all of you must go through very quickly. It is a very simply written, because it's court's own handbook. So in addition to this lecture, I think the handbook on practice and procedure, the examiner may rely upon, and it may have certain aspects which may have missed our attention for lack of time. Now with this, I would like to conclude this lecture, hoping that it will be of use to all of you. I take this opportunity to thank SCAORA, our dear...
Don't thank first, we'll have a questionnaire also, question and answer session also, because many questions are in the chat box.
I was in this flow. I will just give this thank you speech and then I will take all the questions. Or you want me to say the thank you speech after the questions? All right, let's go on with the questions.
Whatever is convenient.
I hope I did not take too much of time.
Meenakshi, please ask the question.
Yes,
Thank you,
Meenakshi.
sir. So I'll just quickly take up the question that have been asked. The first question is asked by Mr. Omran Khan, that question of dispute of tax between central government and state government, does it come under the original jurisdiction?
Yes, it can come in original jurisdiction. There is no bar, because all these judgments say that there is no bar. So what I will say is that even if they go to a suit court, which is a district court, that may not be able to say that I don't have jurisdiction. It is not necessary to go to the Supreme Court. But if the government, the union or the state feels that it should go to the Supreme Court, then the Supreme Court also cannot shut them out.
So
I hope it is answered. Yes.
Yes. So the next question asked is by Mr. Rajesh Kumar. He has asked that in a general bench with a smaller strength, refer the matter to CJI, and then the CJI decides the bench strength. Is it correct?
Yes, because that is when I explained the master of the roster, the protocol is, although they may even write in the order just this, that the matter should be referred to a larger bench. But however, since it's for the Honorable CJI to constitute a larger bench, nobody else has this jurisdiction. So necessarily it will have to go to the Honorable CJI. But yes, I must answer. I think what must be going on in his mind is the Honorable CJI may not be in a position to apply his mind as to whether he should refer it to the larger bench or not. When the division bench has requested him, then he must constitute a bench. Which bench to constitute is his prerogative.
Right, sir. The last question is asked by Ms. Rohini Kalgutkar. She is asked, what is the prescribed court fees for criminal SLP?
Criminal SLP, see the prescribed court fee, they should go through the table. But from what I remember of my AOR days, which has been more than 1.5 years now, is that there is no court fee in the Supreme Court for criminal matters.
Yes, sir. Thank you so much, sir. I, on behalf of the SCAORA Executive Committee, I extend our heartfelt gratitude to sir for being an esteemed part of the SCAORA AOR Lecture Series 2025. Your illuminating insights on practice and procedure have been invaluable, and your expertise in highlighting the key judgments and crucial topics for the exam will undoubtedly benefit the AOR aspirants. Notably, sir, your achievement in securing the second rank in the AOR examination lends significant credibility to your guidance, providing aspirants with a first-hand understanding of what it takes to excel. Your thoughtful analysis of previous question papers has provided clarity on important questions, giving aspirants a significant edge. We appreciate your gracious presence, sir, and look forward to have you on board again for the future SCAORA lecture series. And thank you everyone who's watched this lecture in large numbers. I, on behalf of SCAORA, wish everyone a very best of luck. I will request now the secretary to conclude the lecture series.
Thank you, sir. It was very informative. Some of my funders also refreshed now.
Some of my funders will also refreshed when I was preparing for this lecture.
Sir, now we'll be looking for you for that 29th lecture.
Yes.